Dr. Tristan, a qualified medical professional, practiced as an anesthesiologist before transitioning to pharmaceutical medicine in 1989. By 2006, he became the global medical director for Reckitt Benckiser Pharmaceuticals in the United States. Later, after RBP's demerger, he became the chief medical director for Indivior. It is worth noting that Dr. Tristan holds a medical license to practice in the UK but has not practiced clinically for many years. The allegations against Dr. Tristan stem from a case in which he pleaded guilty in the United States on December 17, 2020, to causing the introduction of a misbranded drug into interstate commerce, which is a misdemeanor under Title 21 of the United States Code, Sections 331 and 333. Following his guilty plea, Dr. Tristan received a sentence that included a $100,000 fine and 1 year of probation. However, it is alleged that he did not promptly inform the General Medical Council of his criminal offense, despite self-referring to them on January 11, 2021. The specific incident leading to the allegations involved a medical affairs manager at Indivior, reporting to Dr. Tristan, submitting faulty data to Mass Health, state Medicaid provider in Massachusetts, in October 2012. The data exaggerated the difference between pediatric consumption rates of Suboxone film and Suboxone tablets. Radars, a research organization instructed with Dr. Tristan's approval, provided the information. The medical affairs manager further compounded the error by sharing a peer-reviewed chart that added to the impression of exaggeration. The tribunal is considering whether the actions outlined in the allegations would be considered crimes under the Business Protection from Misleading Marketing Regulations 2008 or the Human Medicines Regulations 2012 if they were committed in England and Wales. To summarize, Dr. Tristan, a former global medical director for a pharmaceutical company, faced allegations related to a guilty plea for causing the introduction of a misbranded drug. Dr. Tristan faced allegations based on events that occurred in the United States. On December 17, 2020, he was convicted in the United States District Court Western District of Virginia for causing the introduction or delivery of a misbranded drug into interstate commerce, which he formally admitted. He was sentenced to pay a $100,000 fine and 1 year of probation, all of which were admitted and found proved. However, it is alleged that Dr. Tristan failed to promptly notify the General Medical Council of his criminal offense, as outlined in paragraph 3 of the allegation. The tribunal is tasked with determining whether this failure and the conviction would constitute criminal offenses if they had occurred in England and Wales. Dr. Tristan's counsel admitted and thus it was found proved certain paragraphs and sub-paragraphs of the allegation. During the tribunal's deliberations on the facts of the case, they considered the burden of proof, which lies with the General Medical Council, and the standard of proof applicable to civil proceedings, which is the balance of probabilities. In other words, the GMC must demonstrate that it is more likely than not that the events outlined in the allegation occurred. The tribunal was reminded of Rule 34, which states that a certificate from a competent court officer indicating a criminal conviction is conclusive evidence of the offense committed. The legally qualified chair advised the tribunal that it can independently consider the overseas case and make its findings without the need for expert references. This principle was established in the case of Schulze Allen versus Royal College of Veterinary Surgeons. Regarding Barnett v. GMC, the legally qualified chair amended their proposed legal advice after taking into account representations from both parties. The chair agreed with the argument that the tribunal was entitled to fill a gap in the information and reach its own assessment without relying on expert opinions. Dr. Tristan had agreed to a written plea agreement, pleaded guilty, and was convicted on August 31, 2020, at a remote court hearing. He was sentenced on December 17, 2020, and self-referred to the GMC on January 11, 2021. The tribunal considered relevant sections from the GMC's Good Medical Practice, which clearly outlined a practitioner's obligation to report criminal charges to the GMC without delay. Dr. Tristan's defense claimed that he was not formally charged until December 2020, but the tribunal disagreed and found that the information and signed plea agreement constituted a formal conviction, which was confirmed at the sentencing hearing in December 2020. The tribunal determined that the 4.5-month delay between Dr. Tristan being charged and his self-referral to the GMC constituted a delay under good medical practice. Therefore, this paragraph of the allegation was found to be proved. The tribunal adopted a narrow approach in determining whether the offense committed in the U.S. would constitute a criminal offense in England and Wales. It compared relevant sections from the U.S. law to the Business Protection from Misleading Marketing Regulations 2008 in England and Wales to assess comparability. The tribunal concluded that the representations made by Indivior to Mass Health constituted advertising under the 2008 regulations, as it aimed to promote the supply of Suboxone film. The tribunal also found that the U.S. offenses and the offense in Regulation 8 of the 2008 regulations involving conviction of a company and potential prosecution of officers were analogous. Analyzing Dr. Tristan's role at Indivior and his knowledge of the false and misleading data, the tribunal inferred that his failure to prevent and promptly correct the misrepresentations amounted to neglect. Given that both Dr. Tristan and Indivior were convicted for failing to correct the same false and misleading statements, the tribunal concluded that the offense to which Dr. Tristan pleaded guilty in the U.S. would also be a criminal offense in England and Wales. In summary, the tribunal found the allegation proved, as Dr. Tristan's self-referral to the GMC was delayed, and the U.S. offense for which he pleaded guilty would constitute a comparable criminal offense in England and Wales. During the impairment determination hearing, the tribunal considered all the evidence presented during the fact stage, including testimonials in support of Dr. Tristan. The GMC argued that Dr. Tristan's fitness to practice could be impaired due to either his misconduct or his conviction. The GMC emphasized the importance of public confidence in the medical profession and highlighted Dr. Tristan's lack of insight, minimizing behavior, and failure to report his conviction promptly. On the other hand, Dr. Tristan's defense argued that his conduct leading to the conviction was a one-time event from over 10 years ago, and he had shown remorse and taken steps to prevent a similar situation from happening again. The defense asserted that Dr. Tristan's integrity had not been questioned, and the offense did not involve patient harm. They pointed out that Dr. Tristan had completed his sentence without complaint and demonstrated a mature and conscientious attitude. The GMC relied on relevant case law and GMC guidance to argue for a finding of impairment. They claimed that Dr. Tristan's actions had the potential to put patients at risk, brought the profession into disrepute, breached fundamental tenets of the profession, and involved dishonesty. The defense countered that public confidence would not be harmed if impairment was not found, and Dr. Tristan had taken the necessary steps for self-reflection and remediation. Regarding the reporting delay, the defense explained that it was an unintentional mistake, and Dr. Tristan had gained insight on the importance of prompt reporting. The tribunal first considered whether Dr. Tristan's delay in informing the GMC of his conviction constituted misconduct. The tribunal concluded that Dr. Tristan's failure to report his conviction without delay was a serious breach of good medical practice and fell short of the expected standards of conduct for a doctor. Regarding the conviction itself, the tribunal acknowledged that Dr. Tristan had served his sentence and was changed by the experience. The tribunal emphasized that the purpose of fitness to practice proceedings is not to punish but to protect the public. The tribunal took into account the length of time since the events leading to the conviction and the absence of any other concerns during that period. The issue of insight and remediation was crucial for the tribunal's determination. The tribunal examined passages from Dr. Tristan's appraisals and his statement, all of which demonstrated his reflection, acceptance of responsibility, and regret for his actions. Testimonials from colleagues also indicated that Dr. Tristan had gained insight and would be more vigilant in the future. Despite finding that the conviction represented a serious departure from GMP, the tribunal considered it to be a one-time event, and they quoted the guidance stating that all human beings make mistakes. It concluded that there was no risk of Dr. Tristan repeating his actions, and they didn't find his fitness to practice impaired, considering the public interest and the need to uphold professional standards. In summary, the tribunal determined that Dr. Tristan's delay in reporting the conviction amounted to misconduct. However, they found that his fitness to practice was not impaired due to the conviction, considering the length of time since the events, his insight and reflection, and the absence of a risk of recurrence. The tribunal considered whether to issue a warning to Dr. Tristan in accordance with Section 35D of the 1983 Act, despite determining that his fitness to practice was not impaired. The GMC submitted that a warning was appropriate due to Dr. Tristan's serious breaches of good medical practice related to his conviction and delay in reporting it. They emphasized the need to uphold public confidence and professional standards. On the other hand, Dr. Tristan's representative argued that a warning was unnecessary, as he had already been profoundly affected by his conviction and hearing process, and there was no risk of repetition. The tribunal acknowledged Dr. Tristan's insight and remediation but concluded that a warning was warranted to deter future misconduct, highlight the unacceptability of his conduct to the profession and the public, and maintain public confidence in the medical profession. The tribunal found that Dr. Tristan's actions significantly deviated from expected standards and issued the warning. The tribunal therefore determined to issue the following warning in accordance with Section 35D of the Medical Act 1983 and Rule 17 of the Rules. On December 17, 2020, at the United States District Court Western District of Virginia, you were convicted of causing the introduction or delivery for introduction into interstate commerce of a drug that is misbranded, contrary to Title 21 of the United States Code, Sections 331 and 333. You were sentenced inter alia to pay a fine of $100,000 and serve 1 year of probation. This offence, if committed in England and Wales, would constitute a criminal offence pursuant to the Business Protection from Misleading Marketing Regulations 2008. You also failed to inform the GMC of this conviction without delay. This conviction and conduct do not meet with the standards required of a doctor. The misconduct risks bringing the profession into disrepute and it must not be repeated. The required standards are set out in Good Medical Practice and associated guidance. In this case, paragraphs 65 and 71 of GMP are particularly relevant. You must make sure that your conduct justifies your patient's trust in you and the public's trust in the profession. You must be honest and trustworthy when writing reports, and when completing or signing forms, reports and other documents. You must make sure that any documents you write or sign are not false or misleading. You must take reasonable steps to check the information is correct. You must not deliberately leave out relevant information. Whilst this failing in itself is not so serious as to require any restriction on your registration, it is necessary in response to issue this formal warning. This warning will be published on the Medical Register in line with the Publication and Disclosure Policy, which can be found at www.gmcuk.org/disclosure policy.